Good. Okay. Good morning, everyone. Thank you for joining us this morning. My name is Angie Jones. I'm director of the Family Business Center. And today we have with us Carrie Urrutia and Emilie Vassar from Eastman&Smith for our webinar, which is the third in a three-part series. Today we'll focus on employment law liabilities related to COVID. So certainly a hot topic I'm sure you are all dealing with. Before we get started, a few logistical things if you haven't been on one of our webinars before. In a minute, I'm going to hand it over to Carrie and Emilie, and they will talk to you about some issues maybe that they're seeing with the clients, some things that you need to look out for, watch out for, some things that might be they're finding other people are having issues or concerns with, or other questions that they're getting. And then we will open it up for Q&A. The best way to do this is to use the chat feature. So if you're not familiar with Zoom, I think everyone is probably right now. But if you're not familiar or haven't used it, if you hover over the bottom, there's a chat box. You can click on that. It will open the chat box typically on your right. If you have a question, you can type it in there. You can type directly to me. You can type to everyone, and I will monitor that as we go and ask when appropriate. Or you can use the raise my hand feature. If you hover over and click on participants, you'll see your name. And if you hover over by your name, there's a raise my hand. I will watch for that as well. If you have a question that's a little more in-depth that requires maybe some back and forth, feel free to use the raise the hand feature, or just message me in the chat box and say, I have a question that just requires a little back and forth communication. I'd rather ask it versus type it all out. And I will certainly call on you. So with that, we will go ahead and get started. We're going to try to keep this under an hour. So I am going to hand it over to Carrie and Emilie.
Thanks, Angie. Good morning, everyone. I see lots of familiar names. I don't see a lot of your faces. I miss seeing faces, but we're doing the best we can. I'm Carrie Urrutia. I'm a partner at Eastman&Smith, and I practice exclusively in employment law. Emilie Vassar is here with us today as well. She is one of our newer colleagues in the labor and employment law section, and you know, we have been spending a fair amount of our day still advising clients with regard to issues related to COVID-19. It has, you know, kind of thrown us all for a loop. Some of us have been open and working on site since the beginning of the pandemic. Others have been working largely from home, and we're dealing with challenges regarding telework. But, you know, as we have been counseling employers and taking questions, we've found that most of the questions we get fall into one of four buckets. And what I'd like to do is kind of talk about these four buckets a little bit, and then, you know, make this forum as beneficial for you all as possible and open up to questions, concerns that you're having in your workplace. The first bucket, not surprisingly, is masks. Lots and lots and lots of questions about masks. Who has to wear them, when they have to be worn, what do we do with employees who refuse to wear them or say they can't wear them? So we'll definitely talk about some of the issues we've seen in that space. One of the newer issues that we have been seeing a lot of questions about are travel restrictions and monitoring employees' off-duty conduct. Many of us have done a great job with implementing protocols in the workplace that make sure that our customers and our employees are safe with regard to social distancing and face coverings. But what happens if, you know, you have an employee who wants to go on vacation to Texas? In one of the areas where the governor's office has said there's a travel advisory. I mean, how do you handle that employee's vacation request, return to work? What if you are aware that, you know, employees are not engaging in good, healthy habits outside of the workplace? How do you address those situations so you're not putting the rest of the workplace at risk? The third area that we see the most questions about are, you know, simply exposure issues. You know, we've had an employee whose spouse has been diagnosed with COVID-19. You know, what do we do? Who do we notify? What do we say? How long do the employees need to be off? Are they entitled to paid time off? Do we have to shut down our entire operation? Do we have to report any positive cases to the health department or to any other agency? So really coming up with a communication piece and an action plan when you have a positive case at work. And by now, most of our clients have had at least a positive case involving an employee or an employee's close family member. So many of you might be quite adept at dealing with this situation. Others of you may have dodged that bullet so far and are looking for some guidance. Best to have a plan in place before somebody comes in and says, hey, I have a positive test. And then especially now that we are looking at back to school for a lot of our employees' children, what that looks like is very different depending on what district you're in, what school the children go to, what county you're in. And we're going to see some issues with regard to attendance and how do we manage those issues, whether we're covered by the FFCRA, which we'll talk about, or not. Do we want to catch up good employees in our attendance system when they are unable to come to work because of childcare or school issues? And we've definitely had some clients that have been thinking outside the box with regard to how best to engage with employees in advance, and perhaps even surveying employees to figure out, what employees' needs and challenges are, what the company's needs and challenges are, and how best to perhaps structure or restructure starting and stopping times, perhaps days off, to make sure that you as a company can remain productive, employees can remain employed to the extent possible, and we can all get through this without a job loss or unemployment, et cetera. So those are the buckets: masks, travel restrictions and off-duty conduct, exposure at work, and then attendance and time off issues. Before we open up for general questions, which is what I'd like to do for most of the morning, I'd like to make this as beneficial for you as possible. I just want to say a couple of words about each of these topics to kind of tee up some of the questions you may have. First, with regard to masks, unless we've been living under a rock, we do now have a statewide mandate. I still get clients who will call and say, we don't like masks, our employees don't like masks. We are saying we understand and tough in a lot of those situations. This is a mandate. Your business can be shut down if you are not complying. And what we are seeing is, the public is well aware of what the rules are or what they think the rules are, and they do not have any hesitation calling the health department. They do not have any hesitation shaming a company on Facebook or social media if they see that they were rated on by an individual who is not wearing a face covering, or if their coworkers aren't wearing face coverings or those rules are not enforced. Employees have felt free to call OSHA rather than coming to you as the business owner in the first instance. So, we do have a mask mandate. There has already been a mask mandate in effect for businesses ever since the reopening process. So this should not be new to us. Everyone at work needs to be wearing a face covering. There are very limited exceptions, and we get a lot of questions about the exceptions. What do I do if an employee refuses to wear a mask? What do I do if the employee says they can't wear a mask for a medical reason? Just last week, I had a couple of companies where employees have said, it's against my religion to wear a mask. Lots of creative reasons to try to get out of this requirement. There are some workplace exemptions that are built into the existing mandate that do apply to medical issues that employees may have. But what a lot of our clients didn't necessarily understand as we were walking through this process, just because an employee has an underlying medical condition, a respiratory condition that may make it unsafe for them to wear a mask, That doesn't mean that you need to permit them to be at your premises and work with other employees and the public maskless, okay? The EEOC and lots of agencies have been very clear that this is a pandemic, and it may be a direct threat for you to permit an employee to work without a mask, even if they have a medical condition. So, we've really worked with employees and employers to understand, is there any kind of face covering that would meet the requirement that would also, be consistent with the employee's health concerns? If not, is there any other accommodation that would permit them to still work but not expose others in the company and the public to safety concerns? Is telework an option? If telework is not an option, is there, an availability for the employee to work in a isolated area in an enclosed office with the door shut by him or herself? If not, you may have to consider whether, an employee should be given an unpaid leave of absence until such time that he or she can wear the mask, or until such time as the mask requirement is lifted. In most situations where employees are working closely with others and can't always maintain that distance, it is not going to be a reasonable accommodation to let an employee work without wearing a face covering. So we can talk about how you might engage in an interactive dialogue with employees who have legitimate reasons why they might not wear a face covering, or it might not be safe for them to wear a face covering. For those who just say, I think it's a violation of my civil rights. I just hate wearing a mask. I think the coronavirus is a hoax. You can send them home. You can fire them. It's only when an employee implicates some sort of protected classification, like a disability or a religion, where you have to have a little bit more of a conversation with them to see if there's any way to accommodate them being able to remain at work, but still be safe and not subject your other folks or the public to any sort of danger. So bring us your mask questions. We've received hundreds, and some of them, are new and interesting. So we'd love to hear them. The second biggest, and might be the biggest right now, issue that employers are calling about are travel restrictions. It was very easy when there was a mandate that we all stay at home, right? We didn't have to worry about employees going on vacation and employees engaging in risky behavior outside of the workplace, because there wasn't a whole lot of risky behavior for them to engage in. Now we have, employees going on vacation, employees going to mass gatherings, and sometimes we have photos of them doing this on social media. And, employers really want to know, how do we handle this particular situation? We do have a travel advisory now in the state of Ohio, which is updated every Wednesday. So tomorrow we'll have a new map, and you can see this map on Ohio's coronavirus website, coronavirus.ohio.gov. And any state that has more than a 15% positivity rate is yellow on the map. And Ohioans are encouraged not to travel to these states. And if they travel to these states, they are encouraged to quarantine for 14 days after returning back to the state of Ohio. As of August 12th, which was last Wednesday, there were a handful of states that fit within this category: Texas, Florida, Idaho, Alabama, Mississippi, and Nevada. And like I said, these states, flip on and flip off based upon their positivity rates that are monitored on a weekly basis. The issue is this a recommendation from the state of Ohio? Is this a requirement from the state of Ohio? And does it matter for our purposes? So, employers call us and say, hey, can we tell our employees that, they are prohibited from traveling to any of the states on the advisory list? And then we get into questions about, are you an at-will employee? And is this a legitimate rule? Is this something that an employer can mandate? What we do know is we can ask questions. We can put an affirmative duty on employees to let us know where they're traveling. Now, if they know that that the consequences for traveling to any one of the advisory states are severe, you may have an honesty issue, and you may have employees who are concealing from you their travel plans. So that's a balance that we just have to keep going as we're having open communications with employees. I think that sometimes we hear secondhand from a coworker who is aware of an employee's travel plans that weren't necessarily disclosed to the employer. So in many instances, the information gets back to the employer at some point. You certainly can strongly encourage employees not to travel to high-risk areas. You can ask for information about where an employee intends to travel. We generally have not been advising clients to say, thou shalt not travel, period, to Florida or you're fired. There are situations where, if you called me up and said, this is what I want to do, tell me if it's lawful, we could have a conversation. I could say, Emily, I hate your green dress. And if you wear that green dress to work one more time, you're fired. And I could do that because Emily is an at-will employee. And I don't need a reason or a good reason to terminate her or keep her employed. But most companies don't make decisions, especially about, off-duty conduct that are that harsh. So it's better, in my experience, to have open communications about what your expectations are, about safety protocols your employees can take if they are traveling anywhere, including a restricted area. And then, is an employee going to be required to quarantine for 14 days after they return from a restricted area? And if so, do you have an obligation to pay them? And I'm not going to pretend to have a crystal ball and know with 100% certainty how courts are going to interpret these things. They're brand spanking new. There is at least an argument to be made that if an employee travels to a restricted area and returns and is forced to quarantine for 14 days, that might be a reason for 14 days of paid time under the FFCRA, which really, burns people up. Employees' own risky behavior could result in a paid vacation. But there are certainly some that read the regulations that broadly. So talking through what your program is, what your rules are, having open communication so employees feel comfortable telling you what they plan to do is key. So definitely interested in some of your questions, some of the policies or procedures you put in place with regard to employee travel. With regard to workplace exposure, it's always better to have a COVID-19 plan in place. Even if it's not perfect, you haven't dotted all the I's or crossed all the T's. If you do have a positive test, or if you have an employee who says, I've been exposed, it's nice to have a guideline to go to, or at least work from. And in many cases, if you're called upon by a government agency like OSHA, they're going to ask for what your protocols are. They're going to ask for what your written policies and procedures in this space are to make sure that what you do is at least consistent with CDC and other safety types of recommendations. How you communicate with employees, what information and requests you make of employees. Certainly confidentiality issues have been huge in this space. If I know that, Angie Jones has tested positive for coronavirus, I'm going to want to have candid conversations with her colleagues to contact trace and see who has had close contact with Angie. But we know from the EEOC that the identity of the individual who tests positive for COVID-19 is confidential. So we can say someone at UT Family Business Center has tested positive for COVID-19. He or she has been in the office on 3 dates in the last 14 days. We can provide some specific information, but we cannot provide the identity of the employee unless, of course, and in many situations this happens, Emilie says, my goodness, of course you can tell employees it's me. I want you to be able to contact trace and be as specific as possible, but without that consent from Angie, you cannot disclose her identity. And we all as business leaders, business owners, HR directors, we get that by and large, but your frontline supervisors and managers don't necessarily get that. And there's a lot of chatter and gossip on the shop floor about who is it, and I think it's this person. And if your managers and supervisors are engaging in that chatter, you know, that's a violation of the ADA and confidentiality requirements. So how long do I have to keep employees off? Can I test them? Can I make sure they have a negative test before they come back? What can I say to the rest of the workplace? Do I have to shut the whole workplace down? These are questions that we get. With regard to testing, the EEOC has come out and said that while you generally cannot require medical tests of your employees, because this is a pandemic and because the EEOC has determined that COVID-19 presents a direct threat to the workplace, employers can require testing. You can require testing of all employees. You can require testing of employees who perhaps have had an exposure and are out on quarantine. So there is no violation of the law to require a test. Now, the EEOC has also come out and said you can't require antibody testing. That is not a lawful requirement. But employers are permitted to use tests if they require them. They have to pay for them or pay for the time that the employee is off getting the test, and can make decisions based upon the results of the test. We should all still be either monitoring our employees or having employees self-monitor for symptoms. The best way, you know, we found, especially with companies who've had exposures or who have had positive tests, if we're having employees, you know, log in when they come into the office and submit answers to questions about, you know, their temperature, their symptoms, who they've had contact with. When you do have a situation that requires some contact tracing or some communications to determine who has been in contact with Angie Jones or an employee who's tested positive, you know, those types of surveys have come in very handy in that process. So you're still required to do that, whether you're doing it yourself or whether you're having your employees do it. But, you know, it may seem like a pain in the butt in many instances, but it really has been a valuable tool when investigating a potential workplace exposure or notifying others in the workplace that a colleague has been exposed.
Can I ask a few clarifying questions really quick?
Of course.
So, do you have to have cause to require a test, or can you say a blanket, everyone test Friday morning? And
Yep.
then if you require it, you can get the results, right? They can't say I'll test, but I'm not going to give you my results.
That's a great question. So you can, you know, if you had the capacity and the desire, you could have a requirement that employees be tested every single day when they come into work. I haven't seen a client do that. I mean, I do have clients in direct care settings where employees are tested once or twice a week. They cannot refuse, and they cannot, you have access to the information, whether the test is positive or negative, but the important takeaway there is that you maintain those test result records confidentially. So you can't, you know, have a line of employees standing next to one another and say negative, negative, positive, positive. So you have to maintain the confidentiality, but you certainly can test. You don't have to administer the test yourself. You can say things like, you know, you're quarantining for 14 days because you've had contact with someone, you don't have symptoms, but before you come back to work, you have to present us with a negative test result. That is still lawful. You don't have to have cause. There doesn't have to be an exposure. I would just be careful that you are applying your testing consistently. It doesn't have to be every single employee. It could be everyone in a particular department. It could be anyone who has, been exposed or traveled. I would have specific criteria and apply them consistently. One other takeaway that comes up from time to time, if you are testing on site or if you are having employees come to work and have their temperature taken, they should clock in first. This is likely going to be compensable time if you're requiring them to engage in any testing or screening activities on site. You should make sure that's on the clock.
Okay. And a little earlier, you mentioned to release an employee's name, you have to get consent from that employee. Can it be verbal or does it need to be in writing?
So everything's better in writing to the extent you think an employee might revoke his or her consent at some point or claim, I never gave you my consent. So while verbal consent is still consent, I would memorialize it in writing. I talked to Angie today. She gave me a list of the individuals that she's been in contact with, the date she's been at work, and she advised me that we can use her identity when we confirm, her contacts, etc. So I would memorialize it some way other than just, later after the fact saying, oh yeah, I think, Emily said that Angie gave her consent. Because there is a legal obligation to keep it confidential, I would make sure that the consent is memorialized somehow. But you don't have to have a legal document that the employee signs. I would just, have some indication in your investigation or your notes that consent was in fact obtained to reveal the employee's identity.
Okay, thanks. And then one last question kind of on this topic. So if you have an office with relatively few amount of employees, 3, maybe 4, it becomes obvious who tested with someone maybe being out for 2 weeks, and then there's talk about that. Now, clearly the employer doesn't acknowledge it if they don't have consent, but is there any liability on the employer's part because it's assumed and the other employees are talking about it?
That's a great question. And no, there's not, provided that we're not talking about supervisors and managers gossiping about who it might be. Because if supervisors and managers are gossiping and talking about it, it's just as if the president of the company is talking about it and revealing it and gossiping about it. So it's really, really important that even if it's obvious who the person is, that supervisors and managers know that, even if it is obvious, that is confidential information and you're not going to say that person's name associated with the COVID diagnosis or the quarantine, et cetera. All right, we're going to open it for questions. The final bucket, and I'm sure there's going to be lots of questions about this, is, when do I have to pay an employee for being off work for an issue related to COVID-19? If you're not covered by the Families First Coronavirus Response Act, lovingly referred to as the FFCRA, then the answer is generally going to be no if we're talking about an hourly employee. Remember, if you have salaried employees, if they work at all during the week, you have to pay them for the entire work week. But if you have less than 500 employees and you have eligible employees, there are situations related to COVID-19 where they may be entitled to a certain period of paid time. I talked longer than I thought I would. I always do. But, I'd love to hear your questions, your concerns, your comments, your gripes, and we'll try to address as many of them as we can.
Okay, great. That was packed with a lot of really, really good. One question. So if you mentioned earlier that there are people certainly with social media getting shamed, and I've seen it a lot, such and such restaurant is closed down because of, and what are they doing for their cleaning? So if an employee is the one that's shaming the company due to a COVID related thing, is there any recourse for the employer, or is this something that should have been in their handbook prior?
Well, remember that we can't generally take an adverse action against an employee who engages in legally protected activity. And complaining about terms and conditions of employment and safety concerns about employment, complaints to OSHA, even if they take place in social media, and even if they are, disrespectful and you think might really impact the reputation of the company, be careful before you discipline or discharge someone in those circumstances, because it may be that they have engaged in protected activity and you could be violating the law by terminating them for blowing the whistle, if you will, on safety concerns. We've seen that a lot in the healthcare industry early on, where nurses and doctors would say, we don't have enough PPE. Everything they tell you about the safety stuff is BS. I mean, we're using, old, outdated supplies. And there was a lot of litigation coming through the pipeline regarding whether those employees are protected. You certainly can respond with all of your safety protocols, and you can advise the public and the employees about what you have done to respond to a certain situation. And I always like to have a conversation with someone. I'm gonna pull names. I see a few familiar names here. If Kim Cryan comes to me and never expresses any safety concerns, and I see on social media she's bashing the company and complaining about not having enough hand sanitizer stations in the office, I would probably call Kim in and say, hey, Kim, I saw your social media posts. You'd probably get a much better response to your concerns if you brought them to me directly instead of posting them on social media. And for a lot of conscientious employees, that's going to be enough for them to understand, oh crap, my employer is paying attention. They want to hear my concerns. But we are in the public shaming era right now, whether it has to do with cleanliness or whether it has to do with discrimination or discriminatory practices. But be very careful before you take adverse employment action against someone who may be engaging in legally protected activity. It's best to address the situation with facts and not necessarily with discipline to the particular employee.
Thank you. And I should also mention, we do have this on Facebook Live. So if anyone's watching on Facebook Live, you should be able to ask a question that way. And Emilie Waggy is monitoring that. Or if you can't find a way to ask the question, just feel free to email her, emily.waggy, W-A-G-Y, @utoledo.edu. Okay, next I have a mask question. If we have guards around cubicles, can the employees take off their masks while at their desk?
Yeah, so that's a common question. There are some, I don't want to say clarifications, but clarifications in the new mask mandate that address whether barriers, physical barriers and social distancing in the workplace would permit employees to remove their masks. And in some situations, the answer is going to be yes. Generally, we had, if an employee was working alone in a facility, or if an employee was in an enclosed space with a door that shuts. But if you look at the new mask mandate, there is language in there that talks about how you could structure the workplace and even cubicles with physical distancing and actual physical barriers that may obviate the need for a mask in certain circumstances. Be aware though, if an employee is leaving the cubicle, going to the bathroom, going out into the hall to get some papers off the printer, the mask mandate still applies 100%. It would only be when they were in the area that was, specifically addressed in the mask mandate, where they would be relieved of the burden of wearing the mask. So you can,
on that point as well, one thing to remember too, especially if you're trying to, adjust cubicles to meet the mask mandate. So you also want to be aware of the other employees and probably in communication with whether or not the other employees are comfortable with these measures. You could have somebody who said, well, I'm perfectly comfortable with people taking off their mask in their office, but I'm fearful of having, open cubicles in the office. So just be, aware of your circumstance and your communication with regards to that before you make broad measures.
And also talk to the rest of the workforce. I mean, I know we have cubicles, and even if we did have physical barriers and social distance cubicles, there are certain attorneys in the firm who just walk up to employees and say, hey, I need this, can you do that? And that, if there is an ability to do that, for someone to easily walk into that space where someone is not wearing a mask, that is not going to comply with the mandate, and that should be taken into consideration. So
one other factor is in the mask order, that clarification that you can create physical barriers only applies when the workspace is not able to be accessed by the general public. So this would be a private office space area, but to the extent you have a receptionist, for instance, in an area where the public can walk in, that person would not be able to just put up a physical barrier.
So if a company has done what they need to do to follow all of these mandates, but an employee feels that they aren't doing a great job enforcing. So for example, in your instance where an employee does keep coming up to them and they've reported it a few times, but this is still happening, is there any legal liability that the company might have? Like can the employee go back and sue them?
So yes, you want to be aware of that. You want to invite employees to complain or to bring concerns to you if your COVID-19 plan isn't being followed. In many instances, it's not necessarily employees being malicious. It's just, the way we're used to doing business. You should address those concerns. Employees who take, I just did this with an employee who, refused to wear a mask over his nose. He would only wear it under, over his mouth. And those issues, should be addressed with discipline if necessary, and you should be able to show that. So if an employee called OSHA or, filed a workers' compensation claim, which we've seen now, we have all these great things on paper, but the employer's not enforcing them, not making people stay off 14 days, not making people stay 6 feet away from one another. If you have enough information from employees or complaints that you as the company haven't acted on, you really do open yourself up for some liability that you should otherwise be shielded from if you can show that you have as many, if not more, protections in place than are in place when an employee goes to Walmart after work.
In many ways, this is kind of analogous to a harassment situation where, an employer's liability for coworker harassment comes up really when the employee learns of an issue and doesn't respond. So this is the same kind of context. If you learn of an issue and you don't respond, that's when you're opening yourself up to liability. If you don't have a reason to know, or you do respond appropriately, you're protecting yourself. You're not in that liability position.
Yeah. So if an employee tells me that they've been exposed, right, just exposed, but they aren't showing any symptoms, should they be allowed to come back to work? Or is a best practice maybe for an employer to say, no, you shouldn't? And on the flip side, if the employer does let them come back to work, what do they do if other employees say, well, I'm not going to work now because you're letting someone who was exposed come into the office?
The best practice for an exposure is to get the employee out of the workplace for 14 days. There are some exceptions or special rules for critical infrastructure employees that are included in the CDC guidance, but the best practice is to either let the employee work from home for 14 days, have the employee work, in some sort of alternative secluded area for 14 days, but certainly permitting them to work and having other employees be concerned about whether they are at risk for exposure is not good. So, our recommendation is going to be that you get the employee out of the work site for 14 days.
Okay. And is there any guidelines on what's considered an exposure? So for example, I work on a college campus. I'm likely going to walk past someone or possibly be in a room with a student, you know, maybe not direct contact, ideally, or not ideally, we should both be wearing our masks, but it would be a small amount of time. Is that considered an exposure?
So it is an exposure, but when the CDC issued its guidance, it talks about prolonged exposure. And, you know, if employees have been exposed, if they have had household contact with or in close contact with someone who is infected for a prolonged period of time. And by that, you know, most of us use a 5-minute or more. So incidental exposure to someone who may have been infected when you're socially distanced and you have your masks on is not a reason to send everybody home for 14 days and shut down the entire workplace. But if you do have, you know, prolonged exposure with someone, even if there were some protections in place, that is when the CDC recommends that the employee quarantine for 14 days, whether that's just working from home, if that's a possibility. But in many cases, that's not a possibility. If you've got employees who are working on a manufacturing line, you know, they don't really have the opportunity to work from home. They're going to be off. And then the question becomes, you know, are they off with pay? Are they off without pay? And that depends on whether you are covered by the FFCRA. Just having exposure or symptoms and being home doesn't automatically entitle someone to payment, 14 days of paid sick time under the FFCRA. They have to be experiencing the symptoms and actively seeking a medical diagnosis.
Or have been recommended to quarantine by a Department of Health. And with the increased contact tracing that we're seeing with Department of Health, we have certainly seen an increase in people who are being contacted directly by their local county departments of health, and sometimes given a letter saying you have been exposed to this person, you are recommended to quarantine. At that point, provided the company is an employer that's covered by the FFCRA, that person would also be entitled to paid sick leave.
So just a clarifying question. Well, actually I have two clarifying questions, but going based on this. So if someone was exposed and they let their employer know, if they can work from home, if it's been proven that they can work remotely, are employers encouraged to let them do that for 2 weeks? And not
absolutely. Employers are encouraged to let everyone who can possibly work remotely, whether there's been an exposure or not. The return to work protocols for various industries all provide that the employer take a look at its workforce and permit anyone who can work remotely to work remotely. So that still exists out there. So, you know, we've had some companies who have just said, you know, the boss is tired of everyone not being here. You know, yeah, work is getting done, but effective next Monday, everyone's here on site 100% of the time. That sort of dictate is inconsistent with the reopening protocols that still are in effect. So yes, to your question, employees should be permitted to work from home if they can. Even if there is not an exposure, we are still recommending that anyone who can work either all of the time from home or part of the time from home be doing that, working from home to limit the exposure in the workplace.
Okay, did they have a date on that, like through the end of 2020, or is it just that's what it is for now?
Yeah, so it's been extended so many times. I think that there is no date certain when the business safe reopening protocols are set to expire. The paid leave provisions in the FFCRA are set to expire on December 31st. So who knows if that will be extended, if we're still in the middle of a pandemic, what our numbers are, but I haven't seen any effort yet to extend that particular deadline.
Okay. So staying on this topic, our second webinar we had in this series, we talked about employee anxiety in returning to work and fears and how leaders and managers can help help with that. Certainly a big issue right now is employees who have school-age children, and their children are either going back to school or having to work remotely. And for the ones that have to work remotely, there are some employees that are dealing with issues saying, I need to be home with them. And you have some employers saying, well, you need to be at work. And so trying to find, maybe from the employee perspective, maybe what rights they have if they're not symptomatic or showing symptoms, but they need to be home to care for a child or help with the child, but they can still function, they can still do all of their work and accomplish all of their work. So where does that, are employers encouraged in those instances to let that happen?
Well, on this one, to the extent that the employer is an FFCRA covered employer, the employee does have rights with respect to this. So one part of the FFCRA provides for extended FMLA leave for people who are in a situation where their childcare or their school-age children's childcare or daycare is unavailable for reasons related to COVID-19. So this would not have covered them during the summer unless a summer childcare provider was not available due to COVID-19. But as we're all going back to school, this is a very present issue. It's a very present issue for me personally. I have a kindergartner starting on Monday, and it's terrifying. Her schedule is absolutely terrifying. I don't know how it is possible for me to function as a full employee while trying to monitor 45-minute segments of a 5-year-old on a computer. So this is a very, very real issue for a lot of people. And one of the things that's all the more challenging for employers is managing all of the different the different ways that schools are handling this. The governor of Ohio has set this to be a district by district thing, and that means that depending on your employee, you may have 5 different ways they're handling it. You could have some in-person schools, you could have some remote learning only, you could have in-person school but no aftercare, you could have on 3 days, off 2 days. Next week, for the next 2 weeks with my kids are remote with 1 hour a day in person. I mean, it's just bananas, the number of ways to deal with this. So the FFCRA entitlement for employees permits leave when the school is unavailable. And what they have said is that unavailable includes when a child is home doing remote learning or required to be home during remote learning. So to the extent that an employee has to be home with their young children monitoring this remote learning, they do have an entitlement to leave. There are a couple of issues here. One is that if it's an older kid, they may not be entitled to that. If it's 14 and over, they have to show some additional reasons why that's permitted, like if the child has special needs. If the school has given you the option of online learning and you would prefer that, but there's also an in-person option, you no longer have that entitlement because it's not unavailable due to COVID-19, that's the choice to be remote. The biggest thing that I think that employers and employees are going to be facing though is how to manage intermittent leave. So to the extent someone can work remotely, but they may not need to do that all of the time. Maybe they need that 3 days a week, or like in my case, maybe they need to work about a 50% day or 25% day because that's the amount of time that they'll have available to do their work. In this setting, the way that the Department of Labor regulations on the FFCRA are set up currently, they state that an employer can permit intermittent leave when it makes sense with the job, but they're not required to. Now that's up for a little bit of debate. It's certainly a best practice to permit it if you are able to do so from a morale standpoint, recognizing this very difficult issue, managing employee anxiety, but also just to get the most of your employee as you can, depending on the nature of the job. That particular the fact that an employer has to grant permission and doesn't have to may also be up for debate. One court, the Southern District of New York, has already overturned that, saying that that's inconsistent with the FMLA and an employer must permit that intermittent leave. Currently, that doesn't apply to our jurisdiction, but it's likely to change, especially given the fact that when these regulations were initially put in place, this was in April, most schools were just shut down entirely. And then we had the summer. Now we're coming into a world where schools are reopening very differently than they shut down. And these hybrid models, I think, are going to require a change to that intermittent leave policy. So we may see updated regulations, we may see more courts, but either way, it's certainly a best practice to permit intermittent leave to the extent you can. When you're doing this, it's also important for employers to make sure that they have good documentation of how much leave is being taken and what percentage, so that they have that already when they need to apply for the tax credit. Sorry, that was a lot of talking. I feel strongly about this area.
Who are working remotely and you know they have young children at home and you perceive that they may have distractions, I would challenge you all to focus on the output, focus on the employee's performance, not necessarily when he or she may be available. Everybody's trying to make this work, and there are certainly ways to be a good and productive employee working from home, and still monitoring employees, or excuse me, monitoring kids, making sure that they're participating in their online work. So, you know, I think that to make sure that we are treating employees with children, employees who don't have children, sometimes see a gender bias in this. We expect that moms are going to be more hands-on when it comes to kids at home. If an employee tells you he or she can work and hasn't requested leave and is working from home, I would make sure that we're measuring their performance and their output the same way we measure other employees' performance and output. And we're not making sure that, you know, every day at 2:58, if they are not physically present and available to answer a question, they're not getting dinged for poor performance. Because one of the things I've noticed, I've worked from home since March, and I've been more productive. You know, I don't have that time in the morning when I'm getting ready and driving to work, and then I'm logging in and I'm talking to my coworkers and I'm getting my coffee. You know, I've been working earlier, working later, and it's all not only come out in the wash, but I think you'll find that a lot of employees have actually stepped up and become more productive. If they haven't, then address it just like you would in any other circumstance. You know, how can I help you? What's going on? You're not meeting your quota, you're not meeting your performance standards, and, you know, try to focus not on, you know, what may be distracting the employee, but how you can work with the employee to make sure he or she is actually getting the work done. And that's, you know, that's a challenge. And the way you interact with your employees, you know, will differ certainly based upon their roles, but something to keep in mind.
No, that's great. I love the idea of focusing on the output. And it's nice to hear that the legal side of it matches up a lot with what Dr. Janelle Whitmer talked about on the leadership side and how you should handle that. So I appreciate that. Can you just clarify, I'm not sure if everyone knows, what is an FFCRA covered employer?
Sure.
500 and fewer employees.
500 and fewer.
So the normal FMLA only applies to employers that have more than 50 employees. So, you know, a lot of you smaller businesses may not have to pay attention or have an FMLA policy, but when we had the Families First Coronavirus Response Act, it covers a lot of you, many of you. If you have less than 500 employees, you are covered. There are certain eligibility requirements for employees, but they're much different and less strict than FMLA eligibility. They only have to have been employed for 30 days. And even if you don't have any employees who've requested time off, if you are covered by the FFCRA, it's really important that you have the poster up at your workplace. Department of DOL.gov, you can find the form, you can print it off. That'll be one of the first questions that get asked, or the first allegations from an employee's lawyer that we see is, you know, do you have the poster up? Do you have application forms for employees, or have you made them aware of what their rights are under the FFCRA?
Okay, great. Okay, so a clarifying question for the FFCRA. Are symptoms in a COVID test enough to receive FFCRA pay, or must the employee also see a doctor? And then are they still eligible if the test is negative, especially since it took a long time to get the results, or if they still have symptoms?
Yes, they're still eligible if the test is negative. If they're off and are seeking medical treatment to determine whether they have COVID-19, even if it's determined that they don't, that symptoms plus medical treatment is enough, and symptoms plus a test would also meet the definition for qualifying for the leave. Remember, this is just a 14-day period of leave and applies in other situations as well, but off work with symptoms and seeking a diagnosis is one of the qualifying reasons for the FFCRA leave.
Okay. And then another clarifying question, something you said earlier about travel. Just to confirm that it's up to the employer if the employees have to quarantine after traveling to advisory states, or can they, I'm quarantining because I traveled here?
Okay, so that's a good question. We do know that it is not an order. It is a strong recommendation. But you know, particularly if you want to avoid a complaint to the Department of Health, if you want to avoid a workers' compensation claim, it should be your practice to not permit someone. Now, you don't have to hire a PI to follow them while they're on vacation to see if they travel to any of the restricted areas. But if you know they do, then I would say your obligation to the rest of the workforce and to minimize any exposure for liability would to keep the employee off for 14 days. Whether that means they're still going to be productive and just work remotely for 14 days, or if they're unfortunately just going to be off for 14 days, that is the best practice advice.
Okay, great, thank you. And I will say, I saw that Emily put the DOL link that you referred to in the chat feature. So if you don't have it printed off, make sure that you go there and print it off.
The DOL has a number of frequently asked questions too on the FFCRA link there, leave. They are constantly updating them, and that's a really great resource for all kinds of questions. I think there are over 100 questions and answers now up on that site.
Okay, great. So outside of medical, so I know we're closing in on 11, but I just have a few more questions. Outside of any like medical products or medical PPE, does an employer, is there best way to handle PPE waste? You know, maybe used masks or something that's left around?
That's a good question. Yeah. So in addition to sanitizing stations, there have also been special bins for you know, masks that have been used that employees can discard on the way out. Most employees have been permitted to wear their own face coverings at work, which are not even really, they don't meet the definition of PPE under OSHA standards. So, you know, we're not going to have employees taking them off and discarding them at the end of the workday. If, however, you wanted employees to wear a certain type of paper or surgical or cloth type mask, you know, it would be wise to have a disposal station. But, you know, in my experience, people are wearing them out to their cars and not taking them off until, you know, they either get home or they get to their cars. But cleaning, extra cleaning, even if it's picking up garbage left behind by employees, is definitely part of any good COVID-19 response plan.
Okay. And are there any recommendations or guidelines that or anything legally that an employer needs to do to help keep an employee safe when they're required to travel for work? So if they're requiring them to travel, is there anything that they need to do?
So it's important to know that there's if you have employees who travel, for work, I would encourage you to go to the Ohio website, and there is a frequently asked questions link related to the travel advisory. And one of the questions is, does this also apply to business travel? And the answer is yes. So be careful if you're requiring your executives or your marketing director or someone to travel to Texas to attend a conference. That's the same as one of your employees deciding to go to Disney World in Florida. I would make sure that, you know, all of your employees, including your employees that travel, you know, have been given the basic training and materials you would give your other employees about, personal hygiene and frequent hand washing. There are free documents that are on Ohio's website about, how to be safe when you're out in the community, how to be safe when you're traveling by air, how to be safe when you're traveling, period, that I would print out and give to employees. There's also a lot of good guidance that's very reader friendly on the CDC's website that you could provide to employees, especially if they are expected to be someplace that is not their regular workstation as part of their job responsibilities. And I did see a question pop up that I want to address quickly. There was someone who asked if a face shield is the same as a mask. And the answer is generally no. There are situations where a face shield may be an accommodation that's better than nothing, but it is not the same as a cloth face covering that covers the nose and the mouth and is not, contemplated as an appropriate face covering under the business protocols for mask wearing at work. There are exceptions to the mask wearing requirements where it's not feasible for an employee to wear a mask. If there's a safety reason, for example, if an employee is a welder, it's probably not a good idea for them to be wearing a cloth mask. So in that case, it may be perfectly appropriate for you to consider something other than a cloth mask, whether it be a face shield or some other type of protective gear. But generally speaking, for your everyday employee, we have seen employers consider other types of cloth face coverings like bandanas more than the face shield. And
although that may change with the recent studies about how bandanas are basically like.
That's right. So we're constantly getting new guidance, and I think that there is new guidance on the Ohio website if you're an educator about face shields in the classroom. But by and large, an employee says, "Hey, I don't want to wear a face mask to wait on tables. I want to wear a face shield." I would not advise that is acceptable under the current business protocols. So good question.
So let me jump back to travel quickly. If an employee declines work-related travel, necessary work-related travel, does the employer have cause to terminate them? Is that considered at will, or no, because they're declining because they might not want to go to Florida because of health risks?
Yeah, so that's tough. If you have an at-will employee and you need them to attend, the marketing conference in Florida and they refuse, I would probably tell you to try to work with that employee to see if there's another conference in a different state 6 months away from now. But if you say, I don't care what the risks are, I want you to tell me, can I legally fire Emilie Vassar because she will not go on this conference? And I think that going on this conference is essential to the company's success. Probably. That doesn't mean Emily's not going to sue you or at least.
And if the reason is because of a disability, then that also may not be necessarily the case.
Right. So, be careful. Just because you can do something doesn't necessarily mean it's going to be without risk, particularly now. If Emilie says, I don't want to go to Florida, and she has a reason that's completely unrelated to COVID-19, unrelated to health issues, she just doesn't feel like it, then, I'm probably going to tell you to document all that stuff and fire Emilie. But, the more the reasons are related to health and safety or Emilie's personal health considerations, I might say, is there someone else who can go in her stead? Is there a way to postpone this? Is there something more local? Is there a way for Emilie to attend remotely? And the more you can show that you've had a conversation with Emilie and explored all of these alternatives, even if you ultimately say, Emilie, we need you to go here or you're fired, you will at least have gone through that interactive dialogue that even the Americans with Disabilities Act requires that you go through to see if there's any alternative or way to accommodate Emilie not physically being present in that location. So have open conversations, document the open conversations that you're having with employees. Doing so doesn't mean that any of your decisions won't necessarily be challenged. It just means it makes it a lot easier for people like us to defend you if you're second guessed by a government agency or by other employees.
Okay, I think I have time for, I'm going to sneak one more in. This is from the chat. As an employer, we advise employees to stay home if they are sick per the CDC guidelines. But the employee will only qualify for the sick leave if they have symptoms and are seeking a diagnosis. Is that correct?
That's correct. That's correct.
Okay, so if the employee has a runny nose or a cough and has to be off for a week, they would have to use PTO, or it would be unpaid time off?
That's correct.
Unless they go in to get a test.
Yep, if they get a test, then that changes the dynamic. And remember, I know it seems arbitrary, and it's not as though you're cutting a personal check to these employees. There are ways to get this money back through tax credits, but yes, that if an employee, that's a very big difference. And we've had this happen, employees line up to get their temperatures taken, and we send someone home because they're 101. If they just stay home for 14 days and don't seek any other treatment or have a test, that employee is not going to be eligible for paid time under the FFCRA. Whereas if Emily gets sent home with a 100-degree temperature, she calls her doctor and says, hey, my employer just sent me home. How do I find out if this is COVID-19? Can I either make an appointment with you or go get a test? She is going to be covered and eligible for pay under the FFCRA. So they're very fact specific. And, I think they were pulled together pretty quickly. They don't necessarily seem fair in a lot of examples we can provide, but it's what we have right now to work with and what we're bound by until at least the end of this year.
But the one thing to remember here is it's not like, every 2 weeks somebody could get a runny nose and a test and continue to get 2 weeks of paid leave. This is 80 hours total. So once they've used it up, then, that's that. And then they're on their own for PTO or unpaid leave.
Okay, great. I'll get one last question. I know but it's kind of a lengthy situational one. So I'm going to ask Lori to go ahead and unmute and you can ask your question.
Hear me?
Yep, we can hear you.
So we are a small employer and an essential business. We've been open the entire time and only our management can work from home. None of our employees have tested positive, nor their family members, but some of our employees have come to us saying that they might have been exposed. So at the end of June, somebody came saying my brother was in Put-in-Bay, so I'm worried I might have it. He doesn't have any symptoms, she didn't have any symptoms. Did somebody else say that their child, somebody was exposed at the daycare, but not in her room. So we've had 7 employees come to us with these exposure concerns, but we've just been telling them to come to work unless they have any symptoms, self-monitor, wash their hands, sanitize, blah, blah, blah. Is that wrong? Because we would have to close if everybody came.
Well, it's not necessarily wrong, particularly because the two examples you gave didn't give me concern about prolonged exposure. But if you had a situation where it was a husband or whether it was a buddy and they spent the entire weekend together at Put-in-Bay and one of those individuals from the group tested positive, I would then advise you to put those employees off. If you had incidental contact or someone at your child's daycare in a different room with a different teacher, I would say to that employee, just continue to do your self-assessments and your self-monitoring every day. Don't come to work if you have symptoms, all the personal hygiene things that you just talked about. So I think that the 2 examples you gave were not situations where you had, I would say, a more compelling obligation to have the employee quarantine for the 14 days. But, if you talk to the employee and really get an idea about the contact they had with the individual who is tested positive, that will lead you to the conclusion whether there was prolonged contact or not.
Okay.
Right.
Perfect.
And this isn't like, you know, 7 degrees of Kevin Bacon here. Like, you know, we're talking about the employee themselves had prolonged contact, not the employee had contact with someone who had contact with someone who had contact with someone.
Right.
Right. Well, and
But
now
it's good that employees are bringing that to your attention, though. I mean, I think that says a lot about the culture of your company, that they feel comfortable raising those issues and getting your guidance as to how you would best like them to handle the situation. Now, you know, Lori's company is small. Another person here might, you know, have 150 employees and might, you know, handle that situation totally differently. They're both lawful responses, but if you can survive without that particular employee, or they could work from home, it would also be an equally fine response to say, we would prefer that you not come to work for 14 days or you know, work from home for 14 days. But you know, it depends on lots of factors, and I get it. A lot of you are small businesses, and unless you have the prolonged contact and a real need for an employee to quarantine, you're going to err on the side of keeping them at work. And in most cases, you keep.
Wonderful. Thank you.
Sure.
Good. Thank
you.
you.
Fun. We could do this all day long, and we do this all day long. I mean, it's, you know, even when you think you know the answer or you've heard every question, one little twist kind of makes us scratch our heads and makes it fun again. So thank you all. I know this is difficult to navigate, and you know, I'd like to say that there's an end in sight, but you know, keep on doing what you're doing and keep that open communication with employees, and you know, hopefully we'll all come out of this on the other side, you know.
This has been absolutely fabulous. Thank you so much, Carrie and Emily. This is packed with lots of great information. I will let everyone know that we did record it. We will put it up on our YouTube site, and Emily Waggy will send you the link out if there's anything you want to go back and refer to, or please feel free to share it with anyone. Kirsten will put all of our links in the chat feature, so you have the link to our YouTube page, to our LinkedIn, Facebook. We are trying to, our role at the center, especially during COVID, is to try to get as much information and resources out to the local family businesses that we can. So Eastman&Smith has been fabulous about helping. I was saying earlier, I think this might be your 3rd or 4th webinar they've done with us. But we certainly appreciate that and appreciate you both being here this morning. So.
And you can feel free to pass along our email addresses and phone numbers. If there are questions we didn't have an opportunity to answer, just feel free to reach out. If it's a common question, you know, the center can maybe blast out the answer, but we're happy to answer any follow-up questions you have.
Great, certainly. We will include that when we send out the web link. We will include that in the email as well. So, great. Well, thank you. Thank you everyone for joining us.
Thanks everyone. Be safe.
Bye.
Bye-bye.